So while they're there in a sidebar, I want to bring our guests in here. I'm joined here live in the studio with Professor Kirk Burkhalter. Professor, we've been talking a lot about this. I've been trying to get an A in your class by throwing you some hints and what I think. What are you making of this testimony? Because I don't know how or why the defense prepped her in this manner.
There's so much to unpack here, so much to unpack here. So some of the things that jump out at me. One is the defense's position is to show that this has somewhat to do about police misconduct and unreasonable actions based on her police training. So we heard from the outset a lot of talk about what she's trained to shoot center mass, how her apartment's near police headquarters and she should have retreated and called for help, covering concealment, which is what's taught most police officers around the country, and the fact that she didn't do those things. And further, that she didn't administer CPR. And finally, the big one for me was that the prosecution got her to admit twice that had she taken a different action, he would still be alive. And actually, as you mentioned during the break, she could have answered that question differently. So there's so much to unpack with this testimony. I think the prosecutor is doing a strong job here. I've always maintained that this case is going to turn on to a large extent. Should we view her as a police officer or view her as a civilian? I think the prosecution's doing a good job of getting the jury to view her as a police officer.
Yeah, I would agree with those points. I think here for the defense, you're not going to get the acquittal, but you're definitely reaching for the hung jury. You've got to try to get that one or two jurors who you truly think are on your side to really be steadfast and hold strong. Wow. So the direct cross and redirect of the defendant, Amber Guyger, in the case where she's accused of shooting and killing Botham Jean in his own home, where she believed it was her home, has come to an end. Now, whether or not the defense put on other witnesses will be the major question, or whether or not they will rest. But while they take a break for lunch, I want to get some analysis from our experts here, both in the studio and via Skype. We're going to start with Lakai Vincent, who is joining us via Skype. Lakai, how you doing?
Good morning, Brian. I'm good, thank you.
Good. So we're seeing the defendant take the stand and give an assortment of testimony that is at times contradicting the ME, contradicting maybe some of what was said in the opening statement, but she's giving her story. And how are jurors or our audience supposed to interpret that when we've heard so many contradicting facts?
Well, I think what's important, Brian, is that when the defendant gets on the stand, they tell their story. There are not many criminal trials that allow the defendants to get on the stand because you're afraid as to what they may say and what they may do and what may come out about that defendant. But this defendant didn't have any other choice but to take the stand in this case. And so when she gets on the stand, she wants to do exactly that. She wants to contradict the prosecution's case. She didn't have the requisite intent. She didn't mean to. It was reasonable for her to mistaken his apartment for her apartment, and so therefore there's not enough for a conviction.
Yeah. Michael Troiano, you had said something very similar in the past, just earlier in this case, that she had to take the stand. Now that you've seen her taking the stand, hindsight being 20/20, if you were the defense attorney, would you have told her to do the same?
Hindsight 20/20, I still think that she needed to, because at the same time is the prosecution doing an excellent job on cross-examination and really blowing up the defense's case. It seems that way. But one thing that I noticed that I think is coming out that's beneficial for the defense that might not be on top of the viewer's head is she's coming off very sincere and remorseful. And when you make a mistake, which is the entire defense here, a mistake, you need to show ownership of that. And especially when you make a mistake this high of a level, taking an innocent person's life, you need to show the gravity of the situation, how much it's affected you, understanding it's affected others.
Now, I know that before I had gotten on, there was already a direct for our viewers who saw with Jesse Weber, the direct of Amber Guyger. So I want to do a quick recap and look at some of the direct testimony from Amber Guyger and give the professor a moment to jump in. And let's take a look at that video. So I might be saying something a little unpopular here, Professor, and I know we had talked about this, but I think that the most guilty entity here, and I'm sorry to say this, is probably the Dallas Police Department. It seems that this person was poorly trained and not given the facets of the utilities to do her job properly, and she was put into a situation because when I hear if you can't see them being the hands, they are usually reaching for a gun, it seems that her mindset is geared towards, if I don't know if I'm safe, then I'm killing.
Well, a couple of things here. So we don't know necessarily if she wasn't trained properly or whether her training wasn't maintained, or perhaps there were not enough tests or indicators to determine whether she was retrained. We were discussing that police departments and paramilitary organizations. What usually happens, what is usually the catalyst for change and retraining and so forth? Incidents like this. So that's one thing, but it's certainly, I think that, well, in my experience of 20 years with the police department here in New York, it's not so much that when you don't see a person's hands, that means they have a gun. It's just being cognizant of someone will hurt you with their hands, not with their eyes, not with their ears. So you need to be aware of where their hands are. So I think she misunderstood what happened there. Interestingly also is this opened the door during direct for the prosecution to really focus on her training. So if you recall, later on, prosecutors said basically, oh, you want to talk about training? Well, and then he brought out all these documents. So do you recall this? Do you recall this from this class, from that class, from that class, from that class? And it kind of really rebutted all this, I was trained to do X, Y, Z.
Yeah, so Lakai, the professor hit on a buzzword that I want to kind of explore a little, opening the door. I know that we as lawyers kind of use it as a turn of phrase, and maybe some people do or do not understand what it means, but the defense can at times, or sorry, the party who is doing the direct has the ability to focus the line of questioning down a certain line. But when they kind of veer off and go somewhere else, for example, talking about her experience, that would open the door and thus allow the prosecutor to be like, oh, as the professor said, you want to talk about training? Let's talk about training. Do you believe that there might have been some instances where Amber Guyger opened the door that just really allowed the prosecution to be like, all right, let's do this?
She necessarily opened the door to any area or any testimony that they didn't necessarily expect. Just like the professor talked about, once they opened the door in terms of the training that she received by the police department, then it allowed them to go down the rabbit hole and talk about the training that she received. And so I don't necessarily think that she opened the door on any area that they didn't expect or any area they weren't prepared to question her about. I think it was certainly testimony that they expected her to go into, considering that she is trying to cast doubt on whether or not she had the intent.
Michael, I'm going to give you one last question before we go to the break. When we're looking at the testimony, I know that you had commented on her demeanor, the way that she holds herself. A two-part question, I guess. What are you maybe explaining to your clients if they were to take the stand, what they should exhibit, how they should carry themselves? And then two, does Amber Guyger fit the Michael Troiano stamp of approval for testifying?
First and foremost, I explain to my clients, like I think many defense attorneys too, which is to be yourself. Going up there and being a character, whether it's a half-day trial or a 6-month trial, I think is a fool's errand. You have to be yourself, but at the same time, you need to warn them if they have certain tics or mannerisms or things that may turn off the jury. I explain to the client that they need to look interested and taking notes is appropriate, but even if somebody is on the stand with, testifying to a bold-faced lie against them, or the prosecution is making really harsh accusations, or even the judge makes an offhand comment, shaking their head in disagreement is not what the jury wants to see. As far as Amber in this particular situation, I think her demeanor is appropriate. I don't know where the jury's going to go at this point, guilty or not, but I do honestly believe that she's remorseful for her actions, and she's showing such for her testimony on both the defense side and the prosecution, because you see a lot of times where they switch when it's one side of the table and all of a sudden they're amenable to the questions, but when the other side has questions, they have an attitude. I think she's been equal to both sides, and that should bode well for her in front of the jury.
Yeah, I would agree. I definitely want our viewers to jump on lawandcrime.com, watch the live feed, comment, tell us what you're thinking. I'm going to be watching it right now here. Maybe we interject some of your ideas as well, because we want to not only have you hear from us, or the experts, but we also want to hear from you. So we'll see you more after this break.